now in session.
Good morning. Please be seated. This is a time set for oral argument in the State and Arizona Department of Revenue versus House. Two tax cases consolidated, 16-0010 and 16-0014. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal, but you have to keep track of that yourselves. We've read the briefs. We've been through the record. We've conferenced the case this morning, so we're well familiar with we think we're well familiar with the underlying facts and certainly the record and the issues being raised by this case. We're recording the argument this morning, both by audio and by video, and the video will be posted on YouTube in a matter of a few days. So if you really want to see what it all looked like, you can visit the site. Because we are recording this, however, I'd appreciate it if you would identify yourself and your client when you approach the podium. With that, appellant may proceed.
Thank you, Your Honor, and good morning. May it please the court, my name is Casey Dillon, and I represent the appellants, Michael and Samantha House. I would like to reserve 5 minutes for rebuttal. Mr. and Mrs. House are not present today, but with me is my paralegal, Ms. Sexton, who's here to get some experience. Mr. and Mrs. House asked that the court find that Judge Witten's erred in granting the Department of Revenue's motions for summary judgment in this case, because there are material factual disputes to be tried. I'm going to highlight 3 issues for the court today. The underlying case at issue here was brought by the Department of Revenue under Arizona Revised Statute 42-1114. In that, the Department of Revenue is required to establish a prima facie case on several issues. The department has failed to do that in this case. Unfortunately, Judge Witten found that the appellants, Mr. and Mrs. House, were unable to assert their defenses in this case in accordance with Arizona Revised Statute 42-1251. Judge Witten also erred in finding that there is not a factual dispute regarding the timeliness of Mr. House's protest filed in 2004. Finally, Judge Witten erred in determining that Mrs. House does not have the right to contest the underlying liability on behalf of the community in accordance with Flexmaster Aluminum.
Can I ask you a question, counsel, as it relates to the protest of the assessment? I know it's dated. Is it November 12th? Other than that, was there any evidence that your client produced concerning the circumstances of when that was not just prepared, but when it was actually mailed?
Unfortunately, the envelope did not have a legible...
I understand the postmark is not eligible, so I guess my question is, is there an affidavit? Is there any evidence from your client as to when that protest was actually put in the mail, delivered, anything like that?
Aside from the dated protest, which is not akin to a dated mailing, there is evidence, and the parties don't dispute that it could take 10 days for the protest to be delivered to the Department of Revenue, given the Thanksgiving holiday, and the due date of the protest was on a Sunday. We were unable to get an affidavit of the person who actually mailed it, but he would have to be subpoenaed for trial to testify on the date he mailed it.
Was there did your client submit a Rule 56F affidavit saying, I need to get this evidence, but I can't get it for the following reasons, and I need some additional time to get that affidavit, or to take discovery, either of that person or of representatives of the Department of Revenue concerning its handling of mail?
No, Mr. House did not provide that.
You said it was undisputed that it may have taken 10 days for an article of mail to posted in Phoenix to make its way to the department. What evidence was offered on that point?
Well, the evidence of timing when the dates occurred back in 2004, and the Department of Revenue, in their answering brief in this case, did say that it's possible it could take 7 days. We did not deny that.
In the answering in the what brief?
Brief in this case.
Okay, is it 7 days or 10 days? I thought you said 10 a few minutes ago.
Sorry, 10 days. I misspoke. I said 7, 10.
All right, well, we'll ask counsel about that when she gets up.
So, as to the first issue, under Arizona Revised Statute, Section 42-1114, the Department of Revenue is required to establish that there's a levy of tax, there's a delinquency, and that the department complied with the provisions of the law relating to the computation and levy of tax in this case. The Department of Revenue has not made a prima facie showing of all of those factors. In particular, the department failed to show that the tax was actually levied or assessed against the taxpayer. Under Arizona Revised Statute, Section 42-1108, subsection C, the department is supposed to mail a notice and demand to the taxpayer if the tax is deemed final or determined final, as it was in this case. There's no evidence that the department mailed a notice of demand, and the department did not certify in any of the affidavits presented on the record in this case that a notice of demand was filed. This error could be fatal to the department's case under Section 42-1114. Mr. and Mrs. House also had valid defenses regarding the calculation of tax, but none of their defenses were heard by the underlying court, or superior court, because they were precluded from asserting their defenses under Section 42-1251.
Can I go back and ask another question about the whole filing, mailing issue? Okay. Who's got the burden of proof here? Is it the department's burden to prove that the protest is untimely, or is it the taxpayer's burden to prove that their protest was timely?
Under Section 42-1114, the department has to provide a rebuttable presumption that they comply with the provisions of the law. So they would have to prove that they did that, and the taxpayer would have the opportunity to contest that, defend against that.
No, but I think the question is not a rebuttable presumption that the assessment was mailed out. That's separate. But when the department says your protest was untimely, who has the burden to show whether, does the taxpayer need to show the protest was timely, or does the department need to show that it was untimely?
Just point of clarification, do you mean in 2004 when the protest was filed?
Right.
In 2004, it would be the taxpayer that would have to show they timely protested.
Well, just to make sure, how would that make the year make a difference?
Because the Department of Revenue is filed this case to reduce an assessment to a judgment, and as part of that, they have to show that they complied with the provisions of the law. So they would have to show that they met the requirements to assess this tax.
Okay.
It was appropriate for them to deny the administrative appeal rights.
Okay. So, but in terms of the timeliness of the response, do you concede it is the taxpayer's burden to show that his protest was timely?
Yes, I do believe under Arizona Revised Statute 1-218, it puts the burden on the taxpayer, the sender of the protest, to show it was timely filed, meaning timely mailed.
That's under the statute?
Yeah, 1-218, subsection A. So, just to point out on the timeliness of the protest issue, The Department of Revenue made the determination that the protest was not timely based on the date it received the protest. It did not reach that determination based on the date the protest was mailed. If you look at the December 10th, 2004 letter that was offered by the Department of Revenue, the author of the letter stated that the protest was postmarked December 1st, 2004, which the parties agree that's not the case. The December 1st, 2004 date is the date that the Department of Revenue claimed they received the protest, and that's the date they stamped it received.
Well, it may actually be two different dates, because the only date we know, there are two dates we know. One is the date of the letter protesting it. The other date is the stamped date, which possibly only indicates when that stamp was applied as opposed to when the protest was received.
I mean, maybe it sat around.
It could have, because of the holiday, the mail process procedures were not clear.
But we don't know what those were.
Right. Was there any effort on the part of appellant to ascertain that process within the department? In other words, what happens when the letter comes in? How many stations does it go through before it's stamped received? What's possible in terms of how long it can sit in a basket before it's stamped?
The appellant had served discovery upon the Department of Revenue and requested documentation. This issue was first raised by the Department of Revenue in their motion for summary judgment. So it wasn't an issue that they had raised in the pleading or discussed with the appellant until we were at the summary judgment phase of the case. They did not assert that the houses were precluded from asserting their defenses in this case under section 42-1251 until they filed their motion for summary judgment.
So at that time, did you make any effort to determine the process? Didn't it become imperative to your case?
It did. I believe at the time discovery was closed. And so it was an issue that would have to be determined through litigation, through cross-examination of witnesses. That's my recollection. I would have to review the record, but I believe the discovery had already closed in the case and it was being prepared for trial or settlement at the time. I think it would be helpful to discuss section 42-1251 for a little bit of time because the Department of Revenue and Judge Whitten agreed that the language of section 42-1251 precludes the taxpayer from asserting defenses in this case, even though section 42-1251 is part of a subset of statutes that gives the taxpayer a pre-assessment right to contest a proposed audit assessment. So what 42-1251 does is it tells the taxpayer if you receive a notice of assessment, you have 45 days from the date of receipt to contest that administratively. And there are other statutes that outline that process. And section 42-1254 says if you go through this administrative process and you still do not agree with the result, you have the right to file a petition in tax court. And that's not the process that we're under in this case. Here, the state has filed the petition under section 42-1114, and they're trying to assert that section 42-1251 would preclude the taxpayer from rebutting their presumptions raised in this case, and it's precluding the taxpayer from raising defenses. And I think it's important to know that some defenses the taxpayer could raise are regarding the assessment of the tax liability and whether they follow proper procedure to do that. Those are issues that could never have been raised in an administrative appeal process regarding the underlying tax liability. And so I think that the preclusion of the taxpayer to assert his defenses, well, the taxpayers to assert their defenses in this case was too broad. They should at the very least, be allowed to assert their defenses that the levy of tax was not proper in this case, even if the court determines that they are precluded from asserting the underlying tax has not been properly calculated. I also think that Section 42-1254 was not written to allow for that preclusiveness. It does allow for a taxpayer to file a refund claim and assert the defenses. That, of course, didn't happen in this case. The state didn't even try to collect this tax for almost 10 years from Mr. House. And that shows that it wasn't designed to be a complete preclusion of a taxpayer to assert its defenses to pay the payment of an underlying liability, or that they owe the underlying liability. And the statute does use the word deemed. The taxpayer is deemed to have waived its and abandoned the right to question. The word deemed has to have some meaning in the statute. It doesn't say it constitutes a waiver or it is a waiver. It's deemed. It's presumed that they've waived that right. And the Internal Revenue Service has similar statutes. They're not worded exactly the same, but if a taxpayer does not properly contest a proposed adjustment, the adjustment will be assessed against them, and they have limited avenues to contest it, like the taxpayers in this case ultimately did. And then I just want to point out that even though Judge Whitten determined that Mr. House could not assert any defenses in the underlying liability, he also erred in determining that Mrs. House could not assert any defenses to the underlying liability under Flexmaster Aluminum. The tax assessment is an assessment, it's not a judgment. This is the case that the state brought to reduce the assessment to a judgment. And the reliance on CDM of Arizona is misplaced because that involves an actual judgment. I think I'll reserve the rest of my time.
Thank you, counsel.
Good morning. May it please the court. My name is Penny Taylor Moore, and I represent the Arizona Department of Revenue, the plaintiff appellee in this matter. I would like to begin by addressing some of the arguments that opposing counsel made, if I may. First of all, with respect to 42-11-14, this argument is waived, because the houses did not argue that ARS 42-11-14 required the department to make a prima facie showing concerning the items that she stated, like the levy of tax, the delinquency, compliance with provisions of law, the computation. She did not argue that. The houses did not argue that, that the department failed to make a showing because it didn't establish that it complied with ARS 42-1108C in their responses to the motions for summary judgment or in their opening brief. The houses are citing ARS 42-1108C for the first time in the reply brief. So the department did not have an opportunity to address that. So the houses argued in their reply brief that Section 42-11-14 requires the department to make a prima facie showing of the levy of the tax, of the delinquency, and of the department's compliance with all the provisions of law that relate to the computation and levy of the tax. That is not what the statute says. What the statute says is in the action to recover taxes due and unpaid, quote, a certificate by the department showing the delinquency is prima facie evidence of the levy of the tax and the delinquency and the compliance by the department of the provisions of law relating to the computation of the tax, computation and levy of the tax. What this means is that the department, when the department submits a certificate showing the delinquency, the certificate establishes a prima facie case that the department is entitled to collect the delinquency, and the burden is then on the taxpayer to establish that the department is not entitled to collect. So the houses waived any argument that the department didn't establish a prima facie case under 421114 by submitting the affidavit reciting the taxes and interest due based on the department's record. They never stated that the department had not filed a certificate sufficient to establish its prima facie case. They did not cite 421114 or section 421108C in their responses to the department's motion for summary judgments. In fact, they actually quoted at page 21 of their opening brief the portion of the section 421114A that says the department's certificate showing the delinquency creates a prima facie case for the department. But they did not argue at that page or at any other pages on which they cited section 421114 in their opening brief that the department had not submitted a proper certificate.
What's the answer to that argument?
Pardon me?
If not waived, what's the answer to that argument?
The department did provide it, and they do not have an opportunity at this time in this case to contest the assessment, because that time has already, or that has been waived by them because they did not file a timely protest. So they don't have the opportunity to contest the actual assessment. This is a collection matter that the department filed, so it is now for the collection of the tax because the houses did not timely protest their assessment, which then became final.
Who had the burden, who has the burden when the issue is the timeliness of a protest to establish the burden to show that the protest was either timely or not timely?
Well, with respect to the protest, on the untimeliness of that, the department established by its affidavit that the protest was untimely because it was received by the department on December 1st.
Well,
And
I'm not sure that it does show that it was received by the department on December 1st.
Your Honor, the houses did not contest the affidavit of Nathan Martinez, which in the affidavit says, when the department received the protest, and that was on December 1st, they did not at all challenge that.
Who has the burden, I'll ask again, who has the burden when the issue is the timeliness of a protest to show that the protest was either timely or untimely?
I think that the taxpayer has the burden to establish that they timely protested.
And what's the authority for that?
That's under 421115.
421115?
Excuse me, 421251. I apologize. 421251.
1251, okay.
Yes.
Well, that's okay.
So, and under that subsection, or under that, it provides, well, under A is where it talks about that the taxpayer has 45 days from the date of receipt to file their protest. And so the burden is on the taxpayer to file that protest within 45 days.
Right, but I think the question goes to, they have 45 days to file the protest, but when there's a question as to whether they did in fact file the protest in a timely fashion, then that's a different question. Who has the burden to prove that? You have a document or the protest stamped received December 1st, but that doesn't tell us anything about the internal processes of the department and whether it could have been received 3-4 business days earlier than that.
And Your Honor, with respect to the mailing process and timeliness and all of this, the houses asserted this for the first time in their response brief, in their statement of facts. They provided no evidence of the department's mailing process or established if it was protested or they didn't raise this in terms of in the responses to the summary judgment with respect to the mailing processes. That was not raised, and that argument is waived. Michael admitted that the department received, he admitted that the department received the December 1st, that the department received his protests on December 1st in his response to the motion for summary judgment. He admitted that.
I see that in the department's answering brief on appeal, the department does say, as counsel said, while it is possible for a letter mailed from one place to another in the same city to take 10 days to reach the recipient, it cannot be said, even with Thanksgiving, that it is more likely than not to take that long. Well, that's the issue that we're struggling with. Who has the burden to show more likely than not that the protest was timely or untimely?
They would have the burden to show when they actually sent it, and they have not done that. They have a letter dated November 12th, but they did not
But
provide
what's
any
the
evidence.
law? What's the rule or the law, the statute that places on the taxpayer that burden? That's what we're struggling with here.
Well, under ARS 1218, this was raised also, this statute was raised for the first time in the reply brief by the houses. They use that to cite 1218 for the proposition that the protest is considered timely if it's filed within 45 days after the notice of proposed assessment is received, which using this citation or this statute is incorrect because under 42-1251A, the taxpayer must file a petition, and the petition is the protest. So the protest is a petition under 42-1251A, and if you look at 1218A, it accepts petitions and notices of appeal from the filing is complete upon mailing rule.
I'm sorry, say that again? So
So-
1218 doesn't apply?
So 1218 does not apply because the protest is a petition under 42-1251A. So it necessarily implies, because petitions are excluded, are considered filed and received by the department on the date actually received, not the date mailed. And it was received by the department on December 1st.
Well, it was stamped received.
That's correct. That is their process, however.
Well, we don't know the process. That's the point. We're struggling here because the department offered no evidence to say 10 years ago, our process was someone opened the mail on the day it was received and stamped it received.
Your Honor, the affidavit of Nathan Martinez, though, makes it clear that the letter was received on December 1st.
So Ms. Moore, here's what I'm hearing. So with your motion for summary judgment and the affidavit that was submitted, the department submitted admissible evidence indicating, per the affiant, that the protest was received December 1, and that then shifted the burden to the other side to come forward with admissible evidence showing a genuine issue of material fact as to when, in fact, the protest was received.
That's correct, Your Honor.
So it would be your position under that construct that it would be the houses who would then have the obligation to either ask for additional time under 56F or come forward with admissible evidence within the time required for their response to show a question of fact.
Your Honor, I would submit that they would not be able to provide any evidence that they should have provided. In other words, they were required to provide at the motion for summary judgment stage. They were required to rebut this at that time, to provide evidence. And they did not provide any evidence.
Or ask for additional time
Or ask for
to
additional
obtain it.
time.
All right.
Correct.
Is there anything in the affidavit that the department is relying on that says that, and I don't remember it specifically, but to show that the affiant was familiar with the processes of the department 10 years prior?
That was not specifically laid out in terms of 10 years prior. Your Honor, I would argue that opposing counsel, the houses, did not raise any issue with respect to
Right.
Yes.
But our review is de novo. We're looking at the evidence, and I'm wondering, I mean, I inferred, and maybe I'm wrong, and if I am, please say why. I inferred that the only basis for the affiant saying that the protest was received on December 1 was that the protest was stamped received on December 1. Is there any basis to say that the affiant based that statement on anything other than the stamp?
It was the stamp.
Okay.
Definitely the stamp that was, but Your Honor, again, going back, at this point, they did not provide, the houses did not provide any evidence that either Mr. House had knowledge of when the letter was sent, or that anyone else had knowledge. So even if this was sent back, they would have been required to make this, available now. They would have been required to say, at that point, here's our evidence that indeed they sent the letter at this particular date. And they don't have that evidence. And
You're
so
saying this is
even
as
if
good
it
as it
went
gets.
back- Yes, even if it went back, Your Honor, they don't have that evidence. And so, to then, like I said, raise it at this level, they have already waived that opportunity, and they don't have that evidence to be able to provide. If they did, they should have provided it. And then with respect to, did you have any more questions about that?
No, you're good. Thank you.
Okay. With respect to Samantha's rights and under FlexMaster and CDM. As a non-debtor spouse, Samantha only had the rights that that Michael House had. And I know that opposing counsel, the houses use FlexMaster, which states that non-debtor spouses' joint interest in the community necessarily includes the right to litigate the premarital debt's existence and amount, as well as the value of the debtor spouse's contribution to the marital community that may be subject to the marital debt. However, with CDM, it's true that in that instance that the case had been reduced to a judgment. There was a premarital judgment, but the court said in CDM that when FlexMaster described the non-debtor spouse's due process rights to litigate, the extent to which the spouse's community property would be subject to the premarital debt, that meant that with respect to the debt itself, the right includes the right to raise any defenses that the debtor spouse may have to payment. So in other words, what's important is that even though this wasn't reduced to a judgment, that CDM, this case was about a judgment, but what the court was trying to say is that the non-debtor spouse would have no more rights than the debtor spouse with respect to challenging the assessment in this instance. So with respect to Michael's, the motion for summary judgment against Michael, the tax court did properly grant the department's summary judgment against Michael and hold that he was liable for the taxes that the department assessed against him. That was not part of the argument that was raised by opposing counsel in her opening oral presentation. But the department was able to establish that Michael was the sole proprietor and license holder of FOSS. That was undisputed. And that he received the notice of proposed assessment from FOSS and received it signed dated October 7, 2004 on the mail receipt. That's undisputed. That he had 45 days from the date of October 7th to file his his protest to the assessment. That was undisputed. And that that Foss sent the notice of protest, but it was not received until December 1st, 2004, making it untimely. That is something that Michael admitted to in his motion for summary judgment. That was not disputed, so it was not argued. There was no. So at this point, they didn't provide. They, being the houses, didn't provide any controverting evidence that the protest was untimely. And with respect to the time frame between November 21st to December 1st, the houses maintained that it would be, reasonable to expect that the letter might take that long. However, that is not the case. That this, under the Cole case, the inference is not reasonable that if the letter was mailed by November 22nd, that it would be received by December 1st. They tried to.
What's the case? I'm sorry, what's the case? Cole?
Cole. They tried to distinguish that Cole is a criminal case and would not apply, but it deals with permissible inferences. And the case talks about when an inference is irrational, which would be the same in a civil or criminal case, which would be more likely than not standard. The Cole uses this same standard as preponderance of evidence standard that applies in civil cases. So in Cole, they talked about an inference not being reasonable, and in this case, it would not, and they recognize, that this would not be reasonable for the letter to take that long, for it to arrive if it was sent on November 21st and arrived December 1st.
Thank you, counsel.
The issue for summary judgment was not what are the defenses to the underlying liability. It was whether the defendants could actually raise any defenses in the case. The Department of Revenue filed the summary judgment and claimed that Mr. and Mrs. House were precluded from raising any defenses to the underlying liability under Section 42-1251. The Houses did not waive any defenses. In fact, on page 8 of Mrs. House's answering brief, she clearly raised the defense of whether the underlying liability was properly assessed. It was discussed during oral arguments, and it was part of the summary judgment process that was initiated in this case. But again, the issue for the court was whether or not they could even raise defenses at all, and there was no waiver of any defenses in this case. I think there is a clear factual dispute on whether there was a timely protest filed. There's also a legal dispute on whether or not a failure to establish the protest was timely filed would preclude the defendants in this case from raising valid defenses under the action filed under 42-1114.
Counsel, but isn't it true that after the department notified the House, Mr. House, regarding the untimeliness of the filing of the protest, that he did not contest that determination?
It is true, but it's also true Mr. House doesn't recall receiving that notice. There's no proof that notice was not sent certified. So the department hasn't established that they even sent it to the proper place.
But he doesn't dispute. He doesn't dispute it.
He does say he doesn't recall receiving it. And because he didn't recall receiving it, he didn't think he received it, but we have no evidence that it was mailed. I mean, they produced it in discovery. The department produced it in discovery to Mr. and Mrs. House. But that's all we have on December 10th.
Is that as a result of the fact that, as he claims, he was not involved with the operations of the business?
I think that and the fact that all of the notices were being sent to the facility where the business was being operated, not Mr. House's residence, personal residence.
But that's the address that had been listed for the business, correct?
Correct, but the Department of Revenue is also asserting personal liability with regard to Mr. House.
The FlexMaster issue is interesting here, where there are really two aspects to what one might contest, and the argument that the department is making is the assessment became final, essentially, by the failure to protest it, and that's the only thing that Mrs. House is able to protest, able to challenge at this point. She needs to hurdle that in order to get to the merits. Is there another case, another analogy that you found a difference? I mean, I don't see anything in the briefs that really addresses this particular issue.
We've done a lot of research, and there's not something directly on point on these issues. The statutes that the Department of Revenue are relying upon are a pre-assessment alternative to contesting an underlying liability. The Internal Revenue Service has a similar set of statutes, and if you do not file an actual petition in tax court within 90 days of a particular notice, the tax can be assessed, but it does not preclude you from asserting defenses in a different case. For instance, a refund action or an action where the Internal Revenue Service files suit to reduce the assessment to a judgment. And United States v. Graham, which we did cite in our brief, is an example of that. So there's
Well,
not,
your client can't bring a refund action because they haven't paid the tax.
that is true. A refund action is not right. The department did not attempt to collect it, and Mr. House and Mrs. House did not pay the tax. So it's not right. The other issue is, if a judgment is rendered in this case, it would be my understanding that that would preclude a refund claim from later being filed. The minute entry did not carve out that option, and it would take that statutory right away, but it's still available to them if they would pay.
Okay. Thank you, counsel. We appreciate the arguments presented here this morning, as well as the briefs that were submitted on these issues. We're going to take this matter under advisement and issue a written decision in due course. With that, we stand adjourned. Thank you.